In Obergefell v. Hodges, the court really addresses the last question in this area, and that is whether there exists a 14th Amendment due process right for individuals of the same sex to be married. Now, the background in this case is large because this is a number of consolidated cases put together, but all of the consolidated cases were really getting at two primary issues. And those primary issues are, does the 14th Amendment require that states allow individuals of the same sex to be married? And the second issue, does the 14th Amendment require states to recognize individuals who are same-sex who were married in another state? So one, did it require the states to do it themselves? And two, did it require the states to recognize individuals legally married in another state as married within their state? So those are the two issues in this case. Like I said, the background is pretty broad. It involves a number of consolidated cases from a number of states with a number of factual setups, but all of them boil down pretty much to this. They were either couples who sought to be legally married in a state that did not recognize it, or they were couples who were legally married in a state that did recognize it and then moved to a state that did not, and they were seeking that state to recognize their marriage. This case is as, if probably not more so, sharply divided than U.S. v. Windsor. It is again a 5-4 decision with exactly the same makeup as the previous decision. Again, Justice Kennedy writes the majority decision. And Justice Kennedy writes that, citing in large part, citing Loving v. Virginia, that there exists a fundamental right to same-sex marriage, that it exists under the 14th Amendment. Though when I say it exists under the 14th Amendment, understand that the majority opinion doesn't deal really broadly, textually, with the argument of 14th Amendment due process rights, or substantive due process rights. That idea doesn't come up until we get to the dissents. This is, again, another decision that is done, one would presume, because of substantive due process. Given the citation of Loving v. Virginia, it only makes sense that that is the operational mechanic that is going on in this case. But what it means is that right to marry that was retained in Loving v. Virginia has been extended to same-sex couples. So it is not just a right for differently sexed couples to be married, but now it is a fundamental right for same-sex couples to be married. And so it can significantly broadens the stake, that fundamental right. Now, the majority opinion is simultaneously well-written and poorly reasoned. It is one of the most beautiful majority opinions that I've read in my time of reading cases. But a cursory look underneath the language that is used reveals that there isn't a whole lot of substantive argument or reasoning provided by the majority opinion. And that is indeed where some of the individuals in dissent take issue. Chief Justice Roberts, in his dissent, speaks almost immediately to the substantive due process clause. And he says, look, I accept that there exists substantive due process by which fundamental rights are protected vis-a-vis the 14th Amendment. But his argument is we're kind of stretching it now, aren't we? That same-sex marriage bans violating the due process clause seems to be a step beyond what anyone would have intended if we're thinking about fundamental rights that are widely accepted and recognized. Understand there's a fundamental difference from loving to Obergefell. At least he argues so, is that in loving, the marriage is a broadly accepted right. Same-sex marriage in 2015 was not. And therefore, using this 14th Amendment due process to read this into the Constitution as a broad fundamental right really does a disservice to the court, and ultimately really is problematic for the court going future in the way in which it possibly could abuse substantive due process. Scalia dissents pretty much arguing the same thing. He argues about the court's reputation being diminished because the majority opinion lacks clear reasoning and analysis, and that the 14th Amendment really doesn't go this far. That this is not the sort of thing that the 14th Amendment was written to address. That this, we're stretching the bounds. We're really using the 14th Amendment to manipulate things into the Constitution that shouldn't be there. Justice Scalia also argues that this is the danger of judicial overreach, is that we have individuals who are subjecting themselves or injecting themselves as legislators, that they are behaving as legislators, and that they are overturning the laws of a wide number of states. And they're doing so in a fashion in which they're not elected, these judges, and really cannot be checked directly by the people, that this is a legislative issue, and that states should choose whether they wish to have same-sex marriage or not, but the mandating of it is a bridge too far. An interesting caveat for Scalia through all of this is that in oral arguments, it wasn't entirely clear on which side Scalia would come down, but that was primarily because in oral arguments, Scalia was pressing both sides in oral arguments about what is known as the full faith and credit clause. And it seemed to some observers, myself included, that Justice Scalia's argument about the full faith and credit clause was fairly well reasoned. The full faith and credit clause simply means that official acts of one government must be recognized by another. So full faith and credit must be given to the official acts of another government. What that means is states have to recognize what other states do. It's the reason why when I drive 4 miles down the road into New Mexico, my driver's license from the state of Texas is still valid, full faith and credit. But he was having a difficult time with primarily the second question, the second issue in this case, which is that if individuals are legally married, same-sex individuals are legally married in New Mexico, wouldn't full faith and credit require them, if they were to move into Texas, for Texas to legally recognize that as a official act of a state government? And during his questioning, he seemed like that might be an area where he might be willing to be persuaded. But the majority did not go that route, and Scalia does not bring it up at all in his dissent. And I really think that was kind of a missed opportunity for the majority, though the majority wished to go with a much broader and more extensive right, a fundamental right, as opposed to using the full faith and credit clause. Justice Thomas and Justice Alito also both dissented. Justice Thomas is unique in that he rejects that substantive due process exists at all. Whereas, if you remember in dissent, Chief Justice Roberts said, yes, absolutely, substantive due process does exist. Justice Thomas rejects it out of spite and says there exists no substantive due process, which means, well, any number of things for the precedents that we've covered in this last section. And Justice Alito really looks at the nature of the substantive due process clause and argues that we've really only accepted rights that are deeply rooted in our nation's history, and same-sex marriage simply isn't one of those rights, and therefore substantive due process really shouldn't apply in this case. So what we have in this particularized case, to sum it up, is there now exists a national fundamental right for same-sex individuals to be married, and also states have to recognize the legally married individuals from other states. The majority opinion is very textually rich, but it's very analysis poor. And the dissents really take issue with this. And this is largely my argument about substantive due process, is that it's a dangerous tool that if ideologically you are on the side of individuals who are on the majority of the court, you may like the tool for what it gives you. In this case, gay marriage. Ideologically, I completely agree with it. But the method by which the court gets there is problematic. As we know now, there is a 6-3 conservative majority on the court. And issues like gay marriage could come before it again. And all it takes really is that switch to have this fundamental right be overturned, like we may see with abortion in the future, and we may see with gay marriage. Substantive due process works very well when there is wide agreed acceptance of the issue. But when you have sharply divided 5-4 cases, substantive due process can be a pretty dangerous tool.